2014-126, State of Arkansas versus Brian Von Alt.
Your Honor, a plea offer has been made in Mr. Von Alt's case, and it's been revised. We're very close to an agreement in that case. Mr. Kincaid and I need to visit at least a little bit more about the case before it is ready for plea today, Your Honor. And I don't know that it'll be ready for plea today.
Well, I'll put it down to be recalled later.
That's fine, Judge.
2014-129, 2014-130, State of Arkansas versus Michael Strange.
And Mr. Strange appears today on a reappearance date. We have received all the discovery. Plea offer has been made. At this point, Mr. Strange has not accepted the plea. He's not totally rejected the plea, so it just needs to stay on the scheduling order of the court.
All right. I'm ordering him to reappear on October 23rd, which is the pretrial date in both of those cases.
All right, thank you.
All right, you may be excused. 2014-144, State of Arkansas versus Susan Busher. Ms. Busher, you're appearing here today for purposes of changing your plea on the charges in this case.
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out on your behalf by your attorney, Mr. Cooper. Is that correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you are to receive with your attorney?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation of Mr. Cooper?
Yes, sir.
On the charges of possession of a controlled substance, methamphetamine, Class C felony, possession of drug paraphernalia, Class D felony, theft by receiving, Class A misdemeanor, how do you now plead?
Guilty.
You're entering this plea of guilty pursuant to the agreement we've been discussing, and that agreement is set out in writing in this document I'm holding up called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
And in going over this plea statement, do you feel you understand what's contained in this plea statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
The most important of those rights you're giving up are the right to a trial by jury, the right to be represented by an attorney and have the assistance of that attorney at trial. You're giving up the right to confront the witnesses that would appear and testify against you, and you're giving up your right to appeal. Do you understand these rights?
Yes, sir.
And understanding the rights that you're giving up, are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you plead guilty, do you acknowledge or admit to the allegations against you in this case?
Run that by me one more time.
You're pleading guilty. Do you admit that you in fact did the crime that
Yes, sir.
you're alleged to have done?
Yes, sir.
Do you admit that on or about the 27th of May of 2014, let's see, that on or about the 27th of May of 2014 here in Baxter County, that you had in your possession a quantity of methamphetamine,
Yes, sir.
and that you had paraphernalia for the use of methamphetamine?
Yes, sir.
Do you also admit that during this time frame, this same time frame here in Baxter County, that you had participated in having theft of power by arranging for a non having the meter jumped to obtain electric power?
Yes, sir.
All right. And I think the total amount was something over $2,000. Do you acknowledge that?
Yes, sir.
Based on those statements, the court at this time will find that the defendant has freely and voluntarily entered their plea of guilty, done so after consulting with an attorney, and has acknowledged the facts that constitute the crime in this case. Based on that, the court is going to find that the defendant is guilty of possession of a controlled substance, methamphetamine, possession of drug paraphernalia, Class D felony, and theft by receiving, a Class A misdemeanor. On that basis, the court at this time will impose the following sentence. The court is sentencing the defendant to 5 years supervised probation on the 2 felony cases, with those sentences to run concurrent, and also concurrent with a 12-month probation on the theft by receiving. All of those, as I said, all those sentences will run concurrent with each other and be subject to the standard terms and conditions of probation of this court. Pursuant to the agreement, the fourth charge in this matter, that of hindering apprehension, is null prost on the motion of the state. The court is imposing a $200 in court costs, a fine of $1,000, public defender assessment of $50, a public defender fee of $150, the statutory DNA fine of $250, drug crime assessment of $125, the booking administration fee $20, and ordering the payment of restitution in the amount of $2,795.35, which it's noted there may be some additional when all is said and done, but at least as of this date, that's what the court is ordering in the payment of restitution.
Judge, that's her half. Is that, co-defendant will pay the other half, but
I
if he
see.
doesn't pay, she has to pay.
I see. Based on those, based on that, the court is placing the defendant on probation, as the court stated. Subject to the written terms and conditions of probation of this court, the court is reviewing and has signed the terms and conditions of probation, which are attached to the plea statement. Court notes that Ms. Busher has herself signed those written terms and conditions of probation, acknowledging that she has read, understands, and will comply with the terms and conditions of probation. That'll be the order of the court. I'm going to direct that, Ms. Bushy, that you meet with the probation officer at this time and get set up on probation.
Okay.
Payment on all of those obligations that I set out will be due and payable starting within 30 days at a minimum rate of $100 per month. That'll be the order of the court. You may be excused.